Hello, welcome to our Touchstones of Democracy event on the U.S. founding and constitutional culture. My name is Laurent Dubois. I'm the academic director of the Karsh Institute of Democracy, which hosts this series, and we are delighted to welcome you to this virtual event today. I'm going to just briefly introduce our two speakers today and who will enter in conversation, and then leave it to them. We're delighted to have with us today Jonathan Gienapp, who is associate professor in the Department of History at Stanford University and the author of a book from 2018 published with Harvard Press called The Second Creation: Fixing the American Constitution in the Founding Era. Thank you for joining us from California today. Appreciate it. And then our very own here from the University of Virginia, Christa Dierksheide. I was practicing that and now I almost got it. Who is Brockman Foundation Jefferson Scholars Foundation professor at the University of Virginia and the director of the Center for the Study of the Age of Jefferson. She is the author of a book called Amelioration and Empire: Progress and Slavery in the Plantation Americas, 1770 to 1840. That was published by UVA in 2014, and is now working on a book called Jefferson's Rising Generation: The Hemmingses and Randolphs in America and the World, 1820 to 1900. That will be published with Yale University Press. I should mention that Jonathan Gienapp's book was selected as the 2019 Best Book in American Political Thought by the American Political Science Association, very prestigious award, and that the book that he's working on now is a history of the preamble to the U.S. Constitution, currently entitled "We the People of the United States: The Struggle Over Popular Sovereignty and Nationhood." And we'll be hearing about both those works today. I'm going to hand it over to Christa to lead the conversation. Thank you both for being here today. Appreciate it.
Great. Thanks so much for that introduction, Laurent. And you almost got that last name.
I'm going to work on it someday. Yeah, we'll have to do another event together so I can get it just right.
You go for another round. Yeah. So I'm really thrilled to be here today with you all and to be speaking with Jonathan Gienapp, such an eminent historian of the constitutional era. So I just wanted to start, Jonathan, by sort of talking a bit more about your first book, Second Creation. And I wanted to start by asking you, what led you to this era? What attracted you to the constitutional debates, especially, since we sort of know that this is well-trodden territory, a lot of people have written a lot about it. What was it that had that sort of spark that drew you in?
Thanks, first off, Christa, for participating in this conversation with me, inviting me to be here, and to Laurent and all of you out there watching. So it's a great question, because I didn't set out to write a book focused on this subject, on how the Constitution was understood and debated after it was written and ratified. As you say, there's many large libraries could be filled with books that have been written on the subject of the making of the United States Constitution. So what drew me to it was I spent a lot of time, as so many scholars of the subject had, in the before period, the 1770s and 1780s. How do you get from American independence to the construction of the federal Constitution itself? And I felt as though I was going over a lot of familiar terrain, and I was trying to find my own way in. And then I thought to myself, okay, I know a lot about debates over the Constitution at the Constitutional Convention and during the year that followed, what's called the ratification debates, when the drafted Constitution was considered by the American political public whether or not it would become fundamental law. I thought, well, what happened after that? I knew a fair amount about the politics of the 1790s, the struggle of the first party system, politicians dividing into Jeffersonians and Hamiltonians and the like. But how did the Constitution fit in to all of this? And I discovered that in especially the first Congress, there weren't just a whole lot of constitutional debates, there were very interesting ones. And what really struck me was, here were people trying to understand what you do with the Constitution, how you set up a working government, with really no rule book or playbook to go by. That unlike us today, who have hundreds of years now of experience and practice and precedent and precedent laid down by the Supreme Court and a whole series of things that establish a set of norms and practices that guide us. Here you have people basically trying to build the car as they're driving it, and the debates reflected that. That even if debates focused on something pretty small and narrow at first, they soon expanded pretty broadly because it wasn't entirely obvious what the Constitution was and how you might implement it. It didn't come with a user's manual. So what I was starting to see was this period was actually enormously creative and deserved, in my estimation, to be regarded as such, because all that stuff had to be invented. People were charting terrain that didn't have a clear map, and they had to explain what you do with it, and they had to do it on the fly while debating these urgent political questions. So it was a pretty explosive period. So at that point, I was really pulled in and thought, okay, this changes how I think about the early Constitution, and perhaps I can convince others to think about it differently too.
Yeah, no, that sounds, that's great. I mean, I love that you sort of stumbled upon that, right? You hadn't set out to really write about this period, so it surprised you. Were any other scholars looking at this period in this way? In other words, was there a kind of prevailing view about how scholars were interpreting the debates that you were looking at sort of after the fact, or was this really new territory in terms of scholarship?
It was new and not new at the same time. So lots of people had been looking at the kinds of debates I ended up looking at, but they were divided across the academy in interesting ways. So I came to realize, as I did not initially, that a lot of legal academics working in law schools and in constitutional law were interested in some of these debates in ways historians had not been. Or historians had been interested in some of the debates, like probably the most important constitutional debate of the post-ratification years, the debate in Congress over whether or not to charter Alexander Hamilton's proposed national bank, something that's now more famous thanks to the musical Hamilton. Historians had long looked at that, but less for its constitutional dimensions and more for what it said about emerging partisanship, political coalitions, what pitted people on one side or the other of the issue. And what really struck me when I looked at the legal literature, which is where people were taking the constitutional issues more seriously, was there was a sense that the Constitution has been written and ratified. So now we're in this different space where people are not making a constitution, but merely interpreting one. Mm-hmm. And what I tried to add was to show how there was a lot of gray area between those two things, precisely because so much of what went into just interpreting the Constitution required passing judgment on these larger considerations that we would consider part of making a constitution, figuring out what it is that you're even interpreting. What does it even mean to say the Constitution means something? If everybody in Congress claims they're trying to follow the Constitution, and then they start arguing about it, and you realize you don't agree on the terms of debate, you don't even agree about what you're arguing over. That one person has a view of the Constitution that is quite different than another person. Mm-hmm. So you then start to realize there's this competition for how to define these terms of debate, how to define the Constitution, which is as important in some ways to making a constitution as what had happened years prior in Philadelphia at the Constitutional Convention. So I thought the legal literature often presumed that what we know now, the sort of tidy categories of constitutional debate, interpretation, and doctrine, they use them as a guide to the debate. And I tried to then understand these debates minus all of that scaffolding. And so in that regard, I found people who had been working on it, but they had been working on it in a way that I thought was less based in the 18th century than it could have been. Mm-hmm.
No, that's great. And I should say that, Jonathan, part of the reason your work is, I think, so fabulous and so impactful is that it talks not only to historians, but to legal scholars. I mean, you've really managed to bridge a divide there that very few scholars are able to do. And so I love that part of your way into this was to sort of tackle the legal literature as well as the sort of prevailing historiography. I'd like to drill down on the novel claims in this book. So can you just sort of outline for us what your sort of principal claims are in second creation, and how that sort of moves the needle on constitutionalism?
Sure. So one of them I just alluded to, this idea of rather than treating the making of the Constitution as something tidily contained to the years of 1787, 1788, see all of the ways in which it necessarily spilled over into the years that followed, not merely because they needed to flesh things out, they had to establish some precedents that didn't exist, they had to fill gaps and silences, but because they really truly had to create a working understanding of what constitutionalism even was under this new system of federal governance that would have at the heart of it this instrument called the Constitution. But then second of all, how because of that, because this was such a creative period where people could do so much and move things in so many different directions, see the transformations that followed from there. And one of the things I try to chart in the book is how a particular conception of the Constitution as more open-ended and uncertain began to give way to new ways of thinking about the Constitution and conceiving of it that saw it as more finished and circumscribed. And I see a particular pivot around the word fixity or fixing that is in the subtitle of the book. So if you think of the word fix, what does it mean to fix something? It has this interesting ambiguity that it can either mean to repair something that needs change, or it can mean to cement something in place so it isn't changed. Mm-hmm. And I was particularly struck how in the debates in the 1790s, there was this impulse to treat the Constitution as the kind of thing that needed fixing, elaboration, repair, additional scaffolding, and how that subtly gave way to newer ways of talking about it that tried to treat it as already fixed in place. So I chart the rise of particular ways of talking and arguing about the Constitution that emphasize especially its history, which was not that distant at the time, but if you're standing in 1794 and 1795, say, and you have an urgent constitutional question in front of you, it was striking to me that more and more people were drawn to the idea of let's figure out what people thought or did or intended to do, in some cases our own selves, 7 or 8 years earlier at Philadelphia or during the ratifying conventions, and how that kind of historical, archival exhumation became a more central part of constitutional culture. So the implications of that, I think, are a few. One, if we take seriously the idea that the period of constitutional creation lasted much longer, I think that changes what it means to think about the Constitution itself, rather than thinking of it as something that's laid down as a particular moment in time, and then all that follows is people trying to make sense of it. We start to see the ways in which making and interpreting are much more intertwined. But then two, what I try to really emphasize is that some of the more familiar ways that we think about it, ones that are really essential to modern constitutional thinking, are often the non-disputed starting point in Supreme Court interpretation or in arguments in law schools or the public sphere, are actually contingent and optional, that there was nothing essential about the Constitution that required us to speak in those terms, to assume that the Constitution needed to be interpreted in those kinds of ways, that there's a history behind it. And if we better understand the historical processes that made those things seem natural when they weren't natural in any particular sense, then that's an invitation to recognize how a lot of the ways we talk about it could be changed or might demand justification anew, rather than saying, well, we have to talk about the Constitution this way because the Constitution makes us. Instead, recognize, even if we've been playing this game for a long time, maybe there are different ways we could play it, and we haven't been willing to see that or able to see that because we've our imagination has been foreclosed upon.
Yeah, great. So I'm really interested in this emphasis on fixing and fixity that you brought up. And I know that you've told us a few minutes ago that the part of what's so exciting about recovering these debates is and sort of the mindset of these politicians debating these things is that they didn't have a roadmap, right? You said they're sort of building the car as they go. But I'm wondering to what extent the British Constitution may have influenced what they're doing in the latter 1780s and 1790s, which of course was unwritten, but had this element of, I think, fixity, at least the way I've interpreted, as well as flexibility. So I don't know if you want to say a little bit more about that, and if you could disagree, of course.
Well, that's enormously important. That's something I really try to emphasize in the book, that it is sometimes presented as though US constitutionalism, and especially the US federal constitution written in 1787, marks this pretty clear and decisive break from what came before, which was life under the British Constitution as members of the British Empire, as subjects of the British Crown. And I like to see a lot more continuity. I think there's a lot more continuity. And I think the reason for that is in some ways kind of obvious. What did Americans know about constitutionalism when they declared independence in 1776? Everything they knew was the British Constitution. They had spent years and years and years, especially in the lead up to the revolution, arguing about constitutionalism, about what the British Constitution required, mandated, entitled them to. So their working habits of mind, of what it meant to do constitutionalism, of what it meant to appeal to a constitution, of what it meant to engage in constitutional interpretation, was entirely structured under that system. So if that's true, it takes a lot to unlearn all those habits. Now, plenty changes between 1776 and 1787 and 1776 and 1800. But because they had already developed this robust set of assumptions for how you describe an authoritative standard that is above, in theory, all people with political power, and how do you bring to bear that on the situation before them, there are so many ways in which that bled naturally into what they were doing now. So people like to say the British Constitution was unwritten and customary. What makes the US Constitution so different is it's written. And there are important differences attached to that, but there are also ways in which that particular difference didn't matter all that much. You see all sorts of ways in which after 1787, people arguing under the US Constitution still think of it in many of the same terms that had driven understanding of the British Constitution, most especially refusing to just think of the US Constitution as a written text, as something whose content is sort of neatly encased in that particular kind of technology. There are all sorts of ways in which they gesture beyond the written document and assume that's obvious and natural and readily draw on their experience under British constitutionalism. Now, under British constitutionalism, you mentioned that there was more flexibility and a different idea of fixation or fixity. And that's also something I think is really important. That under the British Constitution, there was this idea that we now find strange, that the Constitution was both unchanging and constantly changing at the same time. So the thinking was that over time, as you had political and constitutional debate, you had these big moments where you worked out what the fundamental rights of English subjects were. You created new constitutional understandings. You, in a very important sense, changed the Constitution. But often that was described as all you really did was you got in better touch with what the British Constitution itself had always been. So if you think of it in sort of the model of a person, that you maybe change over your lifetime in a lot of ways, but your essence, your soul, what really animates you doesn't change, but maybe you, as things that are less essential change, you get in better touch with who you really are. They often talked about the British Constitution that way. And initially, I think people talked about the US Constitution that way. One of the things I try to chart is how that idea of how something can change a lot and never change is pulled apart and helped create our modern understanding, where it seems like an either or. Either the Constitution is a living document, as living constitutionalists suggest, it evolves with society, it's adaptable, it's changing, or it's unchanging until formally changed, or the idea that it's sort of fixed at its inception, which usually is attached to the idea of constitutional originalism. So part of what I try to describe in the book is how that way of thinking, which would have been deeply unnatural and weird to people in the 18th century, became natural. I mean, that's a lot of what I think historians try to do. Things that we take for granted, how do people who didn't take them for granted, how do those processes eventually emerge?
Yeah, no, that's great. I mean, one of the things I really love in the book is the way you're able to demonstrate the changing and unchanging conception of constitutions and to contemporaries, in the 18th century, and how that feeds into or has influenced the rather zero-sum way many people see the Constitution today. So I wonder if we could push into that a little bit more and talk more fully about how recovering these debates, as you have, changes how we think about the Constitution today, or how you think it should. That would be great.
Yeah, well, I'd like to believe that if we take more seriously the sort of depth and scope of constitutional creativity in this moment, we will, one way to see it is we'll stop doing constitutionalism as snapshots, and we'll instead try to understand it more on the metaphor of movies, right? That it's not a matter of what did the First Amendment originally mean? And as though you're trying to return to this discrete moment and figure out what was laid down, you instead recognize that to do that, you have to understand a longer process, a more dynamic process, and all of the context that surrounded it that went into it. So it calls for sort of a deeper form of historical consciousness. Mm-hmm. And then in particular, a willingness to see that so much that we take for granted perhaps shouldn't be taken for granted, that we talk about the Constitution in a lot of ways. We see it very much distinctively as a text, as something laid down on parchment that is behind glass at the National Archives that people take pilgrimages to see. That there are other ways to think about the Constitution than just that, than just a piece of parchment behind glass, that there are more structural ways to think of it that dominated 18th century thinking, that a constitution was like the constitution of the human body or the constitution of a building. It was a description of how things held together. Those understandings don't disappear in the 1780s or 90s. So my hope is that it will awaken a new kind of consciousness, or at least an ability to think about constitutionalism in new ways, especially if there's a particular emphasis placed on the significance of the founding generation, as there long has been in American civic culture, and for quite some time has been in American constitutional decision-making. The Supreme Court, especially recently, turns a lot to history and tradition, the invocation of originalism. There's a real attention paid in the modern moment to what the founding generation laid down. Well, I'm trying to suggest we should rethink what they did. And we should recognize that it's a more complicated and interesting story. And that should influence how we talk about what we are supposedly bound by today. And that there might be a more dynamic give and take between past and present that sometimes there is.
Yeah. It strikes me that in a certain way you're asking or hoping that 21st century moderns will be thinking in much the same way that these leaders did about their own conceptions of the Constitution. They're thinking historically. Context really matters to them. You said earlier that they make a big distinction between what happens in 1787 and what they're thinking in the 1790s. That's how they're thinking about it. And am I wrong in that we sort of need to recover that kind of mindset or approach to the Constitution?
Yeah, we certainly could. It's obviously easier said than done because, again, part of my argument is once you have 200 years of playing a game,
Right.
You get pretty thick understandings of how it should be played. And, if you imagine you pick up a ball, I sort of use this metaphor in the book, and there's sort of no set rules about what counts as scoring with the ball or what's out of bounds, what's inbounds. Well, if you play it for a long time, then people have established pretty strong norms on what inbounds and out of bounds is. But even if that's the case, even if it's hard to fully go back, and there might be good reasons for that, it's still worth imagining doing exactly what you describe. Okay, putting ourselves back in 1791, when James Madison and others are bitterly debating the constitutionality of the national bank, and recognizing the free-for-all that they were engaged in, and asking ourselves, what are the costs and benefits of not being in that moment? But at least starting from the premise, why don't we think about what it would look like to embrace that creativity a bit more? So I wholly endorse that mental exercise for sure.
Yeah. It's hard to defamiliarize something.
Yes.
This is great, Jonathan. I'd like to move on to the project you're working on right now on the preamble of the Constitution. And I was just wondering why you chose to pivot to that. And what should we know about the preamble that we don't?
Great question, because on the one hand, the preamble is arguably the most famous part of the Constitution. You asked ordinary Americans what's in the Constitution. There's a decent chance that, especially because of something that was drilled into them when they were in elementary school, it would be the words of the preamble. So it's in some ways very familiar, very well known. But on the other hand, it's long been erased from the Constitution. It has been understood for a long time not to have any legal content or any meaningful content. It's sort of treated as throat clearing. The real Constitution follows. And this has been Supreme Court doctrine for over a century. The idea that the Constitution is really nothing more than rhetorical flourish.
Mm-hmm.
And part of the reason I've become drawn to this topic is because in researching the first book, in those debates in the 1790s, where there weren't rules and there weren't these sort of set precedents or expectations, people used the preamble all the time.
Mm-hmm.
And not just rhetorically. They used it in substantive constitutional argument, and in particular, to make the case that the national government had a particular ambit of power that others claimed it didn't. So they were really using the preamble to emphasize the powers of the national government. And as I dug into it more to try to figure out, well, why are these extraordinarily capable, smart people, many of them the leading lawyers of the time, making these constitutional arguments that would be laughed out of court today? All right, so that always gets one's attention as a historian. If smart people are doing something that looks very irrational and weird in the past, that's usually precisely the thing to try to understand, because they're obviously doing it because they don't think it's a unintelligent non-starter in constitutionalism. They think it has real power. So the more I've looked into it, I started to realize, oh, the preamble is a nice encapsulation of a particular way of talking about constitutionalism and thinking about it that was vibrant and vital in the earliest years and was slowly erased over the course of the 19th century. So I was really interested in understanding both where that way of thinking about the Constitution came from, why people thought it had this vitality, and then why it was that it was drained of its significance to the point that it's now just assumed, everybody on all sides, that the preamble's not in a legal sense part of the Constitution, that it's just rhetoric. How does that process work? And I'm trying to understand in this book exactly why that happened.
Mm-hmm. No, I think that sounds fabulous. And as you said, it's the part of the Constitution everyone knows, and yet no one pays attention to. So what are your, if you can share, what are your initial conclusions about recovering this as sort of critical piece of constitutional thinking?
Yeah, so what I'm trying to first establish is why the preamble more broadly had significance at the time it was written. And that requires understanding a way of thinking and debating constitutionalism, and then within that, a particular understanding of American constitutionalism itself. So among a certain cross-section of important leaders, people who tended to be strong nationalists, who following independence think that the United States is foundering in part because the national government is not strong enough. They've not given enough powers to the national government, that what the United States needs to genuinely hang together and solve its problems is to strengthen the idea that it is first and foremost a nation. And in particular, there are two individuals that I really focus on in the 1780s, James Wilson and Gouverneur Morris, who in a nation that is obsessed with its so-called founding fathers, these are not household names. Many people have never heard of them. They're both from Pennsylvania. Gouverneur Morris is a New Yorker, but he represents Pennsylvania at the Constitutional Convention. They're both lawyers, and they are both strongly committed to the idea that the most important thing that happened legally with the Declaration of Independence, with the decision to break from Great Britain, was that the United States was created itself as a nation. It was not a confederacy of 13 independent sovereign states. It was genuinely a nation. And they did their best to make this argument in the 1780s, and they showed up at the Constitutional Convention in 1787, convinced it was right and eager to create a constitution that would, as best it could, reinforce this controversial reading of what we would call sort of sociology or political theory of a kind, like what is the United States in the most essential form. And as they saw it, and this gets to the broader way of thinking about constitutionalism that I think made this also urgent, is that people assumed that when you tried to understand what kind of powers a constitution of government had, you always needed to answer a question that came before it, which was, what is the political community that this constitution of government represents? There was this idea that usually went under the umbrella of social contract theory, that the creation of government followed two steps. The first step, people formed a political community, a social compact, and then they formed a government. And whatever that government could or could not do had a lot to do with what you had hypothetically done at step one. And in the context of the American Federal Union, the urgent question at step one was, well, what literally are we? Are we a confederacy of states? Are we a nation? Are we something in between? But there was a clear understanding, there was consensus that steps 1 and 2 were related. So Wilson and Morris and these other people who defended nationalism emphasized, well, the United States of America is a nation, so the Constitution that represents it will have certain broad general powers to legislate in the national interest. But they knew not everybody agreed. So the contest in Philadelphia is partly an effort to reinforce that vision as best they could. And Wilson and Morris arguably play the largest role of anybody at the convention in actually writing the Constitution on the two key drafting committees that come halfway through the convention and toward the end. And the committee that comes at the end, the Committee of Style, that is basically Gouverneur Morris as a one-man committee. It's a little more complicated than that, but he would later say, I was the one who wrote the Constitution, and people agreed with him. He dramatically overhauls the preamble and changes it from "we the people of" list the various states to "we the people of the United States," and then adds all these concrete ends that the Constitution is being ordained and established for, to see to the general welfare, to and all the rest. Mm-hmm. So they think the preamble is this evidence of what the United States is. that we, the people of the United States, says something of enormous importance. And then people spend the 1790s saying that and having this big argument about whether or not that is right. So the preamble is grabbed hold of because it seems to be this piece of evidence about what the United States is and therefore how much power the national government actually has.
Mm-hmm. No, this is really fabulous. I love the formulation that you're making. Well, that Wilson and Morris are sort of grabbing a hold of here, which is these two steps that you have to define the political community first before you can decide what system of government fits that community. And I think a lot of the public don't realize how contested the idea of nationhood versus a loose confederation of states was in this period, and that they were not at all the same thing, and that a lot of the debates over the Constitution stemmed from those disagreements. Like, for example, yesterday we read in my class, the students read the Treaty of Paris, right? When the king acknowledges American independence in 1783, he doesn't call them a nation. He acknowledges that they are sovereign and independent states. So external, and when a number of foreign nations recognize American independence, they are recognizing it, the states, not as So I think recovering that and how the preamble is being maybe retold by people who really are sort of behind this idea of nationhood is really, really important for our understanding of the goals of this period. So that's fabulous.
Well, no, I could just quickly, I mean, you're so great latching onto the Treaty of Paris because that picks up on this ambiguity in the Declaration of Independence, that it both says one people, I mean, that's how it begins, one people, but it says free and independent states, which suggests this multiplicity rather than unity. And there's this great moment at the Constitutional Convention in June where Luther Martin, who is much more committed to state power rather than federal power, emphasizes, well, what happened in 1776? All of the American states were thrown into a state of nature. They left the state of nature by creating independent communities in the states, and only then did they confederate. And then James Wilson dramatically unfurls his copy of the Declaration of Independence that he walked around with, and reads from it and offers this controversial, but in his eyes, correct reading that you have it exactly wrong. That's not what we did, right? This reading of the Treaty of Paris that others had offered. No, we were born a nation prior to being individual states.
That's a wonderful story. And I think, and I emphasize this to my students and others, the radicalism and novelty of claiming that America is one, that there is this sort of one people in 1776, and that there's a real tension, and this idea is really contested by contemporaries who are like, what are you talking about? That's not what this is about. So I love that your project is sort of in part recovering those debates and the contested nature of this project. So that's great. I think we might be sort of getting toward the end of our discussion time. Jonathan, is there anything you want to say about how you want your work, people to think about your work or interpret your work beyond the academy, maybe even among sort of the lay public?
Sure. Well, as I've alluded to before, a lot of what I look at is not strictly speaking academic in terms of the times we're living through and how American history influences important things about the present. So a lot of people are interested in the founding because that is so routinely a lightning rod for modern debate over who we are, where we should be going, and then more specifically, how we should interpret the Constitution and which interpretations of it are right or wrong. And one thing I'd like people to take from it is that this invitation, and there are lots of ways to reject the premise, but if we're going to turn to history to try to illuminate important things in the present, be they political or legal, be they a particular case coming before the Supreme Court, it's often a lot messier and richer than people who traffic in that space want to believe or tend to suggest. So a key thing to think about is that a true engagement with the past requires a much deeper and fuller form of reflection than those debates sometimes permit. So are we going to try to figure out whether some big area of American life should be decided by what the founders laid down? Well, that's going to require more than snapping some quotes from 1787 and 1788. That's going to require more deeply reflecting upon what was going on in that period, how they were debating, and how those debates were changing. Because only in that context, that more historical context, I think, can we arrive at a genuine understanding rather than a shallow one.
Great. Thank you so much, Jonathan. I think we're going to go ahead and pivot to some questions, if that's okay, because I had a few already in the queue here. So I'll just start with the first I have, and that is, what could serve today as a shared challenge of the magnitude of inventing the Constitution? How could Americans be engaged in sharing that challenge?
That's a great question. So I suppose the straightforward answer would be to have another constitutional convention. Something that a lot of people in the 18th century thought would be relatively common. It's hard to know exactly, and has of course never happened again. It's something that a lot of people lament, especially now, because they think there are things that are very broken about the Constitution. And the foundation of the Constitution, that we the people are sovereign, to get back to something the preamble emphasizes, has never been something we've been willing to act upon out of cowardice or trepidation or concern. And whether that's a good idea or not, I mean, that's a complex question. But the Constitution was written for a particular moment and a particular time. I mean, should each state, no matter its population size, have 2 senators? We can debate that. But one thing that is clear is there were particular political reasons why that decision was made in 1787. And does that still work for the United States in 2023? Well, one way to think about it is shouldn't we have a big public debate about how we might change that? Should we have a constitutional convention? That would certainly require people to think more deeply, as people in the 1790s did. Now, it would also take us to a space where there aren't really any rules. I mean, you can't really set rules for a constitutional convention for this, you're empowering the people to do as they wish. Pretty much anything's on the table. And a lot of people find that prospect scary. People are constantly fearful about, well, what would a runaway convention look like? Or they say things like, I'd like a constitutional convention, and I just don't want the people currently in charge to be the ones overseeing it. All fair observations, but that would certainly take us back to the 1790s in a big way. And nothing's stopping us. The Constitution permits that, calls for that in a certain sense.
Mm-hmm. Yeah, and contemporaries of the time, well, I'm thinking of Madison and Jefferson here, and their debate about generational sovereignty, that and their fear that a law would last forever. There would be forever constitutions, that in order for the people to truly remain sovereign, they would need to write a new constitution every generation, which Jefferson cleverly calculated as 19.1 years, right? So that in theory, at least, there should be a constitution in order for that sovereignty to really be sustained. This project has to happen, every so often. And I think we don't think about that, or that debate, about or their fear about forever laws and how it dovetailed or paralleled with their understanding of aristocracy taking root, and power, sort of the dead hand of the past, having this sort of grip on the people forever, right?
Absolutely. Yeah. And I'm glad you invoked Jefferson. I'm sure you teach this a lot. I do too. His radical idea of generational sovereignty, which has an intuitive appeal. No one generation can bind another in such a profound sense that each generation has to rewrite its constitution, or you're living under a form of political slavery. And then James Madison replies, okay, there's a lot to this idea, but we also, for governance to work, for constitutionalism to work, you need a certain amount of stability and veneration, because the law can't work as the law unless people have a certain measure of veneration. So how do you balance those Jeffersonian and Madisonian impulses? Requisite veneration with enough generational change that we, the people, are truly sovereign.
We haven't answered that question yet, but let me go to another question from the audience. Okay, this one is, was there any early understanding that Congress would be the primary branch to identify and protect through legislation unenumerated rights contemplated by the 10th Amendment?
Great question. I assume by that is meant the 9th Amendment, which is the one that specifies that there are rights not enumerated, or that nobody should read the enumeration of certain rights to mean that others don't exist that aren't enumerated. Well, the first thing about Congress, this is an important part of the book that I didn't emphasize. A big part of the reason I look at Congress is because Congress was the institution in 1789 that everyone assumed would be the primary constitutional actor. We live in a world today where we assume interpreting the Constitution and making final decisions on the Constitution falls to the federal courts, particularly the Supreme Court. Nothing could have been more different in the 18th century. Nobody intuitively thought that the court would have anything approaching that role. So Congress is really the one driving the ship and making these decisions. That's a very important first point. Now, what did they think in terms of the 9th Amendment and legislation? They didn't particularly think in those terms, in terms of sort of establishing federal rights that would codify the 9th Amendment, in part because they didn't think they needed to. The 9th Amendment is in many ways this dispatch from a foreign land that we now don't readily understand. What does it mean that there is this enumerated provision in the Constitution that says, don't assume the only rights you have are the ones enumerated? They assumed this was common sense, because when your fundamental rights were not the sort of thing that were created by enumerating them in constitutions. They were things people had no matter what constitutions said. So their understanding would be, this again gets back to the tradition under the British Constitution, that all of the ways in which Americans had defended their rights under the British Constitution would continue on through the end of the 18th century into the 19th century, that Congress wouldn't create federal legislation that said, oh, by the way, you have these additional 15 rights. People would know what they were, and they would fight for them in all of the ways they had, by assembling, by protesting, by petitioning, by writing about them, by doing the things that we, the people, ought to do in a popular constitutional system to cash that out. So one of the interesting things that happen is that tradition slowly wanes. And what we get is the rise of more and more control by the courts. And it creates this mismatch where a lot of things that the Constitution was written to do presupposed a form of constitutionalism that wasn't court-centric. So we have this very strange world we live in now where the courts say, yes, the 9th Amendment tells us we have more rights than are enumerated, but we, the court, can only enforce the ones that are enumerated, more or less. So those rights exist, just we can't enforce them, but we're also in this world where we tend to be the only ones who do the enforcing. So Congress could now step in, and probably should do more of a job stepping in, but we've ended up in this awkward place in part because the 9th Amendment is evidence of a constitutionalism that has disappeared.
Okay, great. Thank you, Jonathan. I have a question here about our definition of the people. The question is, what about the evolved understanding of who the people, quote, are? While the challenges among the political participants in the original constitutional debates were great, they were fairly uniform as white property-owning males. We face a far more complicated environment in which to structure the debates and ensure participation today. Any thoughts on that?
Absolutely. So I think one of the reasons to focus on the preamble is to just pose just that question, that who we are as the people of the United States is a necessarily dynamic, evolving concept. And they had a certain understanding of this. They didn't necessarily assume that the people was sort of frozen in amber, that kind of sociological consideration for how the people are changing would be of constitutional significance. So it's a reminder that in the 18th century, on the one hand, the people who participated in the constitutional debates and the making of the Constitution was quite broad and democratic compared to what had come before, but at the same time was unbelievably exclusionary and circumscribed by any reasonable understanding of democratic participation today, which gets us back to the Jeffersonian impulse about what it means to be ruled by the dead hand of the past. Nobody who's watching this webinar or participating on this chat, and this includes you, Christa, and me, none of us had a say in the Constitution or agreed to it. So it's something that none of us consented to. So what accounts for its legitimacy? Well, one understanding of its legitimacy would be that you have to take that notion of the people's sovereign control of it serious in a more dynamic way that doesn't just take the form of the people can amend it whenever they choose, not recognizing that it's nearly impossible to amend the Constitution, which is a different matter. And instead recognize that the way to atone for the stain that is on the Constitution because it was written at a time when women were not permitted participation in politics, when most Black people living in the United States lived under chattel slavery, and the like, that you have to take seriously a more dynamic version of the people and understand and ask yourself, then what does that mean about how we should interpret the Constitution today? And perhaps what emphasis we place on the historical debates. I'm a historian who's interested in those processes, but that doesn't mean that when we're thinking in modern times, we need to place extraordinary weight on them. The history might be cause to de-emphasize the history for just the reasons that question poses.
And just to follow up to that, I mean, even though you've emphasized, and many people have, right, both the Declaration and Constitution, this sort of exclusivity of these documents, they were inclusive to who? Like, who are they trying to include in that definition of the people in that historical moment?
That's a complex question, because, and this is debated in the concrete on the eve of the Civil War, because the people who defend the Confederacy, the Confederate States of America, are pretty emphatic that the Declaration of Independence, rightly read, what Thomas Jefferson was trying to say as lead author of it, was not all men, but all white men. And other people at the time who were opposed to the Confederate project saw a more universalist aspiration behind it, or said, well, who really cares what Thomas Jefferson or anyone else intended? What we have is what they wrote, and they wrote, all men are created equal. This is what abolitionists for decades had been emphasizing. Believe your lying eyes. It's right here in front of you. So exactly what the Declaration was intended to say on that front is open to debate. But I think the first question to ask is, does it matter? Does what we want the Declaration of Independence to mean hinge on that question? Because it could be, well, surely Thomas Jefferson and other members of the Second Continental Congress had a more circumscribed idea in mind. Or it could be that they recognized their own failures and flaws and were trying to set something up that pointed to a higher ideal. But how do we want to read it? And what are the implications of reading it both ways? And that can go both ways, right? There can both be, we want to see things in terms of the more universal ideal to give us something to strive for, but we also don't want that to be a cop-out to ignore injustices of the past or ways in which the 18th and 19th century was nowhere near as democratic as what we would consider acceptable. So I think those are complex questions for a political public that should be embraced.
Yeah, great answers. Thank you. I have a question here from a watcher, an audience member, who's asking about the parallel between the preamble of the Constitution and what we now know of as Jefferson's Statute for Religious Freedom. So the question is, in looking at a parallel on the importance of the preamble, most of what we know of Jefferson's Statute of Religious Freedom and what is relied upon the courts is the preamble. Thomas Buckley, in his excellent work, argued that including, quote, Jesus Christ in the preamble would be unimportant, just a preamble. Jefferson certainly thought otherwise. What are your thoughts about the parallelism or lack thereof?
Good question. I haven't thought about it as deeply as I now realize I should, but this connects to precisely the sort of thing I'm interested in doing in the project, which is recognizing that it was not obvious how people were supposed to read preambles. Now, it might have been clearer in a statute of the kind that Jefferson's Bill for Religious Freedom was, because there were certain working understandings that Blackstone and other British jurists talked about in various influential legal treatises, that you only appealed to the preamble of a statute if there was ambiguity in the remainder of the statute. So this was a way of discounting preambles and saying, well, preambles aren't really part of statutes. They're just there to help kind of deal with questions that we might call, where you need a tiebreaker, but you can't appeal to it otherwise. So one answer could be, well, a difference here. So something in which there's not a parallel is there's a profound difference between a statute and a constitution, which was one of the things that people who defended their reading of the preamble emphasized time and again. Don't tell me about Blackstone's rules of construction. Don't tell me about how statutes have tended to be interpreted. We're not interpreting a statute. You've just made a category error. We're interpreting a constitution, and we're interpreting a constitution based on popular sovereignty, so that especially changes the game. But the allusion to Jefferson thinking the preamble to his statute was important, I think also suggests that people didn't automatically assume that statutes should be read that way either. That, there's this great moment in the Pennsylvania Ratifying Convention when James Wilson appeals to Blackstone and British legal reasoning to emphasize something about the Constitution. And William Findley, who's a leading anti-federalist and a firebrand and a pretty outspoken guy, says, who on earth cares about what Blackstone thought about anything or what anybody in Britain thought? I was under the impression we had a revolution and that the purpose of that revolution was to break from all those things. So that was a further example of each time people tried to find a toehold in certain things that were in the air, somebody could always explain why the thing you grabbed hold of wasn't relevant because American constitutionalism was so different. So I think even Jefferson talking about statutes saying, yeah, maybe people have specified how we should read statutes. Why are they right? And they're talking about statutes written by Parliament. I don't care. What we're doing in Virginia is different, and my preamble matters. And to me, that emphasizes the broader point that people didn't automatically assume preambles didn't matter. Quite the opposite. And that's worth taking seriously.
Yeah, I love your emphasis on these, on the preamble and the Constitution as really, protean. I mean, that, these things are absolutely embryonic and no one is sure of the meanings of so many pieces that are so many balls in the air, so to speak, that are on the table in this period. And I think that's just a wonderful way to approach this period. I think we're essentially out of time. Looks like it's about 1 o'clock. So I just want to thank you, Jonathan, for joining us today. I found this conversation fascinating, and I'm just constantly impressed at how novel and creative your approach to the constitutional era is. So thank you very much for participating in our conversation today.
Thank you very much for those compliments and for the great conversation.
Thank you also, Christa. We really appreciate your participation today, and we look forward to stay tuned for more events in the Touchstones of Democracy series as well. And thank you all for coming today. Thank you both.
Thanks.
Thank you.